Welcome to Mentoring with the Masters. My name is Alan Bookman. I practice law in Pensacola. I've been practicing there for 35 years and I do commercial litigation, and appreciate your watching this and understand that what I'm going to talk about today is preparing for hearings and dealing with difficult lawyers on the other side. Let me talk about preparing for hearings first. First of all, please understand that all hearings are important. There's no small hearing, there's no large hearing, they're all important. And it's been my experience that you should prepare the same way for every hearing that you go to. Read the file, understand the file, know why you're going to the court. Don't assume that the court knows why you're there. Most judges are prepared. Most judges have read the pleadings, they've read the file, they know what's before them today. If you file briefs or memos in support of your motion, most judges have read that, but on occasion judges don't have that opportunity. Their dockets are full, or they may not have read the information, but don't assume that they understand why you're there. So go in fully prepared, and when you make your argument to the court. Don't worry about making your argument to the other side, talk to the court. Don't waste time with the judge. Judges' dockets are full, they don't want you to waste time. In fact, if you can get them back on schedule, and if you can give them some breathing room, if you've got an hour schedule, if you've got 15-minute schedule, whatever, and if you don't need that entire time, don't use that entire time. Allow the court to take a breather, get back on schedule, and maybe take a break. A lot of people think that inspiration is the key, and it's been my experience that that is absolutely not the key. It's preparation and perspiration beat inspiration 99 times out of 100. If opposing counsel is gray-haired and you think that he or she knows more than you simply because they've been around a long time, that is no excuse for you not to be prepared. And like I said, don't assume that any hearing is too small for you not to be prepared. In addition to being prepared for whatever the issue is before the court, also know the file, because judges oftentimes ask questions beyond what the pleadings are. They ask a question as to other matters of this particular matter. Are there discovery issues? Are there discovery deadlines? Do we need to have a case management conference? You may be there on a motion to dismiss for failure to state a cause of action. You may be there on some procedural matter, but the court wants to know how this matter is progressing, what needs to be done. Has it gone to mediation? So be well familiar with the case so that you can adequately and properly respond to the court. Oftentimes you'll be questioning as to whether or not do I need to have a court reporter present. Try to learn, and you'll get a feel for this as you practice, but learn which times you think a court reporter is necessary. If in doubt, it's always been my experience to err in the side of having the matter reported. Now on minor matters, the motions to quash, or it depends on what the matter is. Obviously you don't need a reporter, it's an expense to your client, and we all have to be economically cognizant of what the client's going through, but err on the side of having a reporter present, so you have to be careful in that regard. Another issue that I've been asked to speak on is how to deal with difficult lawyers. Unfortunately, there are a number of lawyers in our legal profession that are, they feel that the Rambo style of litigation is the way to go, and that's the way to impress their clients, and that's the way to get their job accomplished. I don't subscribe to that. Most lawyers don't subscribe to that, but you will run into the difficult lawyer, the lawyer that will not return your telephone calls, the lawyer will not answer discovery responses in a timely fashion, the lawyer who refuses to schedule a hearing or refuses to schedule depositions. My recommendation is don't get down to their level. Maintain your professionalism, represent your client diligently, adequately, appropriately. There's no need to get down to the dirt and grovel with the other side. You're just going to get involved. It's not personal. Don't let it become personal. You're representing your client, and be professional at all times. I do recommend that and unfortunately there are some lawyers that you have to do this with, is document. Most lawyers, when you call them up and ask for an extension of time to file an answer, an extension of time to respond to some discovery, most lawyers are very accommodating, and they'll give you another week or 10 days or whatever the time frame may be. and you can bank on what they've said. There are some lawyers, unfortunately, that will tell you one thing and then do something totally different. And you'll have to get to learn who those lawyers are. So what I recommend is, and this is probably good in all cases, whether it's a Rambo type lawyer or not on the other side, is if you are requesting something and the other side has consented to whatever you're requesting, drop them an email, put it in writing, just confirm the conversation. I've had situations where I've had lawyers consent to something, I've documented it, and they go in front of the judge and swear that they never did it. And it's always good when you can pull out the communication before the judge, and you're building credibility with the court. And this sort of goes back to the preparing for the hearing as well. But you're building credibility with the court. And the biggest thing that a lawyer can have, whether they're in practice for 2 months or 20 years, is credibility. When you walk into the chambers, when you walk into the courtroom, you want to feel that the judge knows that when you're speaking to the court, that you're dealing from a position of this is something that you really believe in, that you've got a sound legal basis to justify what your argument is, and you know that the judge knows that when you walk in the door. It's very difficult to obtain credibility with the court, and it's very easy to lose credibility. I liken it to a restaurant. It takes a long time for a restaurant to build up a good reputation for good food and good service, and once they have that reputation, you'll recommend that restaurant to all your friends. If you go to that restaurant one time and the food is not good or the service is not good, then you'll tell everybody, don't go back to that restaurant. And the same is true with practicing law and dealing with other lawyers and dealing with the court. As I said, when you're dealing with a difficult lawyer, don't take it personally. Don't get down to their level. Maintain your professionalism, and I wish you the very best of success in the practice of law.